we're going to start. And we're going to start with Newhoff versus Marvin Lumber. And this case is a good example of what I told y'all about with the case where they open the box and they get the paper out and everybody's surprised and people say things. And then later on, they argue about who promised what. And, you know, if business were being done really correctly, everything would be written down in a very clear contract. But as we know from these cases, contracts, it's not just clear written contracts drafted by lawyers that make enforceable agreements, that people do and say things that can create enforceable obligations, or maybe not. In the case where, remember, they opened the box and took out the deed and found out, oh, that not all the children were getting one piece of property, only 2 of the children were getting that piece of property. And they went, oh, we're really surprised, and we won't, you know, ask for our share of the other property if you don't bother us about the property that our dad gave to us. And then they end up in court suing about it later. And that was found not to be an enforceable promise. Why not?
Because there was no consideration.
Remember George and Sophia, they promised to give up their claim and the other piece of property. And the court said, y'all don't have to do that. Why not? I know it was a week ago, but
because there was no consideration.
To remember a week ago. When George and Sophia promised to give up their claim, the court in the end said, y'all don't have to do that, even though you promised to do that. Why not? Well, what have these cases been about? All these cases are about one issue.
There was no consideration.
It's another word for being nice to people and thoughtful about their feelings. But it's also the legal contract term that we've been talking about with every case. Starts with a C. Somebody has got to come up with the word. Don't.
Maybe because it wasn't consideration with them.
Okay,
No?
I see somebody's mouth moving, but I don't hear you, Irina, because let me see. Are you muted?
Yes,
Okay, now I hear you.
because there's no consideration between them.
Consideration, that's the word we're looking for. There was no consideration. Why was there no consideration for Sophie and George's promise to give up their share of the other property? There was no consideration for that promise because why? It's almost hurt.
Maybe because the property was sold. No.
Well, no. So remember what, okay, let's review a little bit. So their father dies, 4 children sitting around. They open the box and it's like Pandora's box, right? Creates this big case that becomes a, you know, history, legal history, because there are 2 deeds in the box. One deed shows that the father owned the property and go to all 4 of his children. But the other deed says actually he's holding it in trust for only 2 of the children, so it's their property. And so the 2 who get the
подивися сюди. Вона надивається екран. Отут.
somebody
Калашников, выключи, пожалуйста, микрофон. Excuse me.
I'm not sure what just happened. Okay. So remember the situation. There are two pieces of property, 4 children. One piece of property goes to all 4 children. One piece of property only goes to 2 of the children. And that's a surprise to everybody that these 2 children get one of the properties by themselves. The other 2 are excluded. So Sophie says, okay, well, we won't take our share of the property we all own if you don't bother us about getting this to ourselves. George agrees. And then when the other property is sold, George and Sophie, they ignore their promise and they go ahead and ask for their share of that property. And the other children say, you promised you would leave this property alone if we didn't bother you about getting the other property. And the court said, that's no good, because when Sophie made that promise, there was no consideration for her promise. Why not? We gotta move faster through these cases, or else we'll be spending the rest of the semester on still stuck on the same case. When Sophie said, we won't claim our share of the other property, there was no consideration for that promise, because why?
Because he got nothing.
She got nothing for that promise. She already owned the property. And so she was saying, I won't bother that property if you don't bother my property. But she already owned it. They had no legal right to it. So she gave up nothing, and she got nothing. The other people didn't give up anything, and she didn't get anything for the promise. So she made a promise, but she's not bound by the promise because she got nothing for the promise. That's right. So there was that's the whole concept. No consideration for the promise. It's not an enforceable promise. So that brings us to this Newhoff versus Marvin Lumber. And anyway, I brought up the case of the box because I said that's the way things happen in the real world. Somebody opens a box, somebody says something, somebody makes a promise. They didn't, Sophie did not consult her lawyer before she made that promise. Obviously, at some point, she talked to a lawyer, and the lawyer said, you don't have to give up your share of that other property because there was no consideration for your promise to give that up. So anyway, so we get to Newhoff versus Marvin Lumber. Again, so is this case, are we arguing about the original contract to install the windows? So remember, this is a case about the Newhoffs get 60 windows installed in their house. They have to have a big house, have 60 windows. And so when they had those 60 windows installed, there was probably some kind of an agreement, some kind of a contract. I'll pay you X amount of money if you install 60 windows. Is that the contract where they're arguing about in this case? You say yes or no and have a 50% chance of being.
No, because in your house, the windows were decaying, and they said it to Marvin, and they promised to change it.
Yeah, that's exactly right. So we're not arguing. They're not arguing about the original contract where they said, I'll pay you X amount for 60 windows. We're way down the road. That's already happened. They've already paid. The windows are installed. And so then this is another Pandora's box that gets opened when the situation changes down the road. And the whole lawsuit is not about the original contract for the 60 windows. It's about a promise that was made later. You're exactly right. A couple of things that you should general things about law, not just contract law, that we should talk about with this case. So a couple of y'all tried to do the case brief on this, and one thing that we got from looking at the ones that I saw, we got to work a little bit on defining the terms. So for instance, in the part where I asked y'all to say, what's the position of the parties? Like, what did each party argue? And some of the ones I got, people talked about what the court said. And in the part about the issue, some people talked a lot about the facts. Some people didn't talk about the facts at all. So we need to work on that a little bit, understanding those concepts. But one thing to notice about this case is they didn't just, as far as the positions of the parties, they didn't just argue one reason. So, well, somebody tell me what are the basic facts of this case? Why did this lawsuit happen?
In 1991, the Neuhaus buy and installed 60 windows manufactured by Marvin, and in 1994 they noticed that many of the windows were decaying, and then they said to Marvin that it was decaying, and they promised to install a new windows. But then they reject it and didn't install new windows.
Well, yeah, and that's good. That's almost right. So what happens is they buy the windows, and notice, and this is like a real business deal. This is the way it would actually work in the real world. Marvin manufactured the windows, but Marvin didn't install the windows. The Neuhaus hired a contractor, a workman who installed the windows that were made by Marvin. So there's a dispute over when Marvin learned about the defect, because the Neuhaus weren't talking to the manufacturer. It's like, if you have windows replaced in your house in Irpin, you probably have a contractor in Irpin doing the work, but maybe the windows had been manufactured in Kharkiv, and that's like, the manufacturer's not anywhere around in the picture. So the homeowners, the buyers, are talking to the contractor, and then eventually the manufacturer Marvin found out about it and sent an inspector. So the Neuhaus, they buy 60 windows, the windows are installed. A couple of years later, they notice the windows are decaying, they're deteriorating. They contact their contractor and say, what's wrong? These are decaying. Marvin, the manufacturer, eventually finds out about it. They send an inspector, and the inspector says, yeah, these are decaying, and we'll replace 33 of them now for free. Is there any dispute about that? Is there any contract issue that the court's having to decide about that? Did Marvin keep its promise to replace the first 33 windows?
Yes.
Yes, they did. So where does the issue come from in this case? Where did the argument come from? So Tatiana, you were on the right track, but the argument came from the fact, so Marvin says, yeah, we'll replace, there's 60 windows in all. They say, we'll replace 33 of them now. Do you remember, why didn't they just replace them all?
Because they got problems with manufacturing.
Yeah, well, and who knows what the real issue was. Obviously, this Marvin company has got a problem with their windows, because you notice that that later on, some of the new windows that they did replace are also decaying. So anyway, but they said, oh, we're having a production problem, so we can't replace them all now. We'll replace 33 now, and we'll replace the rest later. So the argument is about the second part of the promise, about replacing the rest of the windows. And there's several reasons that there's an argument about it. What's the main reason that there's an argument about that? Did they write down in a contract, we will replace 33 now, and we will replace the rest within 90 days?
No.
No,
No.
just promise.
It's completely indefinite. They say, what they say is, we'll replace 33 now, and we're replacing 33 now because we have a production problem. They never really say, and we'll replace the rest within a year, do they? They don't really say, but there's an implication, if we're replacing 33 now because of the production problem, that they intend to, replace the rest of them later. But that promise is never really specified and really nailed down. So it's indefinite. And so that's where, I would keep saying, if you're studying contract law and want to be a lawyer doing contracts, we're studying all these cases that turned into a train wreck and had a problem and went to court. If you're a good contracts lawyer, you never want to go to court, because you don't have these problems with your contracts. And if you're a lawyer advising a business, if you're the lawyer for Marvin Lumber Company, you want to work and train their employees so that they don't go out and make a bunch of promises that get them sued. If you're a good lawyer, you don't want to go to court, and you don't go to court because your contract is good and your business practices are good. So anyway, so this whole argument is over this promise that was made later on, years after the original sale of an installation of the windows. So one thing to note about this case is that they don't just argue one reason, that the Neuhoffs don't just argue one reason that they should get a remedy. They argue lots of different theories. And that sounds like, maybe, Professor, that's obvious. You can argue different legal theories. But in fact, that was not always the case historically. And if you look at these, old English cases, they had different theories. Like we looked at the case of the theory was assumpsit. And assumpsit was over an agreement that was not under seal. And the way it worked in the English courts, if you filed your case under the wrong theory, you lost automatically. It's like you had to pick the right theory. So assumpsit is for an agreement that's not under seal. So if you took a sealed agreement and filed a case in assumpsit in an English court, you would lose automatically. They say, we're throwing you out. This is not an assumpsit case. You picked the wrong theory. Goodbye. And you had to pick one theory. And so it was almost like a magic incantation. And he said you had to choose the right form of words. If you did not pick the right theory to sue under, then you lost. And it didn't matter what the facts or evidence, anything were. So what are the different theories? What are the different legal theories that the Neuhoffs try to sue under to try to get the rest of their windows replaced? They're all listed in the opinion. One's under the letter, big capital letter A, and the theory is what? If you look at your case, you have a copy of the case, which you should have. So this is a little bit difficult by Zoom, but if you look at the case and the court decision, under the big capital letter A, what is the theory that the court addresses first? Look at your case, copy of the case. There's a big capital letter A, and it says what? You see a capital letter A, it says breach of an oral agreement, breach of an oral promise. So that's one thing right there. So a contract is not always written. Sometimes what you say can create an enforceable agreement and be a contract. So when the representative of Marvin Lumber said, in a kind of vague way, he said, we'll replace 33 now, kind of implying they would replace the rest later. And they're saying that's an oral promise. So the Neuhoffs say that's an oral promise. They also say there was an implied warranty. Do y'all understand what a warranty is? It's like, okay. All right, a warranty is like a guarantee by the manufacturer. So when you buy your iPhone, it has a warranty, and nobody ever looks at it. It's probably some 10-page agreement with writing too small to read that goes on, but it explains what the manufacturer will be responsible for, what they won't be responsible for. So for example, if you buy an iPhone and you get it out of the box and the screen doesn't work, can't see anything on the screen, it's just black. Well, there's probably a warranty by the manufacturer that the phone will work and that the screen will work. So you can take the phone back and say, there's a warranty for the screen to work, so you have to replace it. But what if you drop your iPhone in the bathtub? Well,
They replace.
if you drop it in the bathtub, the manufacturer, it will say in their warranties, we're not responsible for that. If you get this phone wet, drop it in the pond or something, that's not our problem. That's your problem. You can buy a new phone, or if you have insurance, but so the warranty is what the manufacturer guarantees, and they'll guarantee, if certain things don't work and because of a defect with the product, then they'll replace it or give you a new phone or fix it. The warranties say what they'll guarantee to do, but that's what a warranty is. It's a guarantee what the manufacturer will be responsible for, what the manufacturer will be accountable for. And so they sue under a theory of a breach of an implied warranty, and there's an implied warranty that our windows will not decay. And they also sue under a Massachusetts is a state in the United States, and every state has laws on warranties. Alabama has laws on warranty, Georgia, every state. So again, when you're dealing with the United States, it's like 50 different countries. You got to, if you have a legal problem in Massachusetts, and you find a, good case that supports your position in Illinois, that's no good because Illinois law is not Massachusetts law. So, although you might argue in Massachusetts, Massachusetts court, you should do the same thing they did in Illinois, but Illinois might have a different statute. So anyway, you have to worry about what state you're in. But Massachusetts has got a statute about warranties and what you have to do to get a defective product replaced or refunded. And then they sue under another theory, which is promissory estoppel. And that's a different legal theory. So there are 4 different legal theories that they try to sue under. They say, 1, it was a breach of an oral promise. 2, it was a breach of an implied warranty. 3, it was a breach of the statutory warranty, the statute enacted by the Massachusetts legislature. And then 4, it's promissory estoppel, meaning that the promise is enforceable. It's not really a contract, but this promissory estoppel is like enforcing a promise because that's the only fair thing to do. Anyway, so do the Neuhoffs win on all those legal theories? Does the court say, yeah, they breached an oral promise that's enforceable? And the answer is no. But y'all have got to get where y'all are answering these questions and not the professor. So actually, the Neuhoffs lose on the first 3 theories. The court says there's not an oral promise we're going to enforce. There's not an implied warranty we're going to enforce. We're not going to enforce the state statutory warranty, but we will enforce the promise under the theory of promissory estoppel. So anyway, this is again, historically a new thing under the law that you can argue all these different reasons that you might win. So in this case, when you're filling out the part, remember the case brief form on the position of the parties, you would have to really fill out, 4 different things because the Neuhoffs argued 4 different reasons that they should win. The court decided in their favor on only one of them, and that was the promissory estoppel. And we will get to that. We'll talk about why they ruled against the Neuhoffs on 3 of them and then ruled for them on 1 of them. Again, I have to tell you, if you find it really confusing and if you find the court's logic really confusing, it's because really it is. And I hope it doesn't confuse y'all more, but I really disagree with the court reasoning really on all of these issues. And it brings me to one thing that I wanted to talk about. Remember, originally on the case brief, I had a section on the procedural posture of the case, and that was about where it is in the court process. And I didn't have y'all fill out that part this time because I didn't think y'all understood enough about what that was to fill it out. But let me tell you a little. I'm going to give you a little what's called civil procedure lesson, how the procedure works in the American courts that you need to know. It applies to contract law. It applies to every other kind of case you might file, contract law or not contract law. And it's and we call it it's the procedures that the court follows, and then also you're talking about what stage you are in litigation. So if you file, this is and again in US law school, we have first-year students take a whole year-long course on civil procedure, about all the different procedures that you follow in state and federal courts. and I'm going to give y'all a 10-minute version of the case you would take for a whole year in U.S. law school. But the point is, usually, if you file a lawsuit against somebody because you say, you promised to replace my windows and you didn't replace the windows, and you go to court and you file a lawsuit, and what's supposed to happen in most cases is the court takes the case in, and then you go to it, you have a trial in the what's called the trial court, the lowest court that hears evidence, and you might have a jury, and you present all their evidence, your evidence of, you present your evidence that they promised to replace all these windows, and then they didn't replace them all, and you're asking the court to make them replace the rest of the windows, and you have a trial, and you present your evidence, and you present your arguments, and the jury decides, and then you get whatever the jury says. But that's the way the court process is supposed to work. But more and more, that's not what happens, because the cases get thrown out in the very beginning before any evidence is presented or any arguments. And you see that happening in this case. The judge is saying, without ever hearing the evidence or presenting the evidence to the jury, the judge is saying you don't have a case as a matter of law. And there are two ways that can happen. And one is if I file a lawsuit against Tatiana, I said, Tatiana, you promised to replace all my windows and you didn't. And Tatiana, she might respond with a motion to dismiss. And that can be granted by the court without ever having a trial and presenting the evidence. And what that means is Tatiana files a motion to dismiss. The standard for granting it is that even if everything you say is true, you don't have a case against me because the law doesn't provide a remedy. And so, maybe a good extreme example of that would be I sue Tatiana because I say, Tatiana, you told me, you said that you were wearing a red dress today and you wore a blue dress, and I'm suing you because you said you were wearing a red dress and you really wore a blue dress. And the court, can grant a motion to dismiss on that because they say, Professor, even if that's true, there's no claim against her. There's no legal claim against her. Even if everything you say is true, that doesn't mean that, you have any legal claim against her. She has no legal duty to tell you what color her dress is, and you can't sue her for, telling you the wrong thing. In this case, this is a motion for summary judgment. And in a motion for summary judgment, the standard for granting that, for the court to throw your case out without allowing you to present your evidence and have your arguments and have a trial, is that under the undisputed facts, there's no legal claim. So the court, so this case originally went to a trial court that might have had a trial, but the trial court didn't. The trial court granted summary judgment on all of the claims, which means that the Neuhoffs never got to have a trial, never got to argue their case in front of a jury. The court threw it out without letting them have a trial. And now it's in front of the appellate court, which is deciding whether that's correct or not. And And a couple of things that are important to understand. Before a court can throw your case out without ever letting you have a trial, they have to take everything that you say in your complaint, your complaint is, your claim you file into the court. The court has to take everything you say as true. So they don't get to, argue about, well, what you said is maybe not true. And they have to view everything in the light most favorable to you, before they can say you have no legal claim and we're throwing your case out. It's arguable whether that happened or not. But before we get to all these legal theories, let's make sure that we understand the facts of this case. I'm trying to help y'all. Y'all seem to be struggling with the facts of the case a little bit. So it's always helpful, and not just in contracts law or contracts class, but everything, every kind of legal problem you ever have, is usually helpful to write yourself up a timeline. And if you read this case and did a timeline, like Tatiana had part of a timeline going, then that will help you understand the basic facts of what's going on. And let's go over that, because if you don't understand the basic facts of the case, you're never going to understand the legal arguments about it. So here's the timeline. In 1991, and your nice professor is doing this for y'all now, struggling through this, but y'all need to get to where y'all can do this for yourselves. And the professor does not have to walk through this with you. And that's why we're trying to learn to read these cases. And it's hard for y'all. It's not your first language, first of all. Legal language is hard to understand for an American, and I hate to think for a Ukrainian. But anyway, since y'all signed up to take U.S. contracts law, we're going to try to struggle through it. But anyway, so for the timeline, in 1991, the Neuhoffs, they agree to buy 60 windows. They pay for 60 windows. They get 60 windows installed. 3 years later, they notice, we just had these windows installed 3 years ago, and they look like they're decaying. And they tell the contractor, they tell the person who installed the windows, there's a problem with these windows. Of course, the contractor is not, the person who installed the windows is not Marvin Lumber Company. Marvin Lumber Company is the manufacturer, and they still don't know. It's not clear when they learned about it. But we know that by 1998, Marvin Lumber Company has found out about this problem. And think about this, and timing is important for everything in law. This is 7 years later. So, and the thing to understand about that, if there's a statutory warranty, or a warranty could come from two places. This guarantee of the quality of the product. It can come by law. The state or the country can have a law that says, what the warranty is, or the manufacturer can give a warranty. If you go buy an iPhone, you probably, you open the box and there's a bunch of paper that everybody just throws away, but that's all this probably, warranty language about what they cover and what they don't cover. And one thing is for sure is that there's going to be a time limitation on the warranty. So Apple, they'll agree, they'll guarantee that their iPhone will work maybe for a year. It might be, I don't know exactly what it is, say it's 2 years. They almost never will the manufacturer's warranty say 7 years later, we're still going to guarantee this thing is working. There's always a time limit on it. So Marvin Lumber finds out about this problem 7 years after the windows are installed. And I don't know, windows, you expect a window to last that long. So maybe there could be a warranty that long, but we know in this case, there was not a warranty that covered it for 7 years, either from the manufacturer or from the, state government statutory warranty. So it's important to understand about this case is like after the warranty on the windows would have expired, 7 years later, Marvin goes, inspects the windows, finds that out of the 60 windows, 56 of them are unacceptably decayed, and that's when they promise to replace 33 of the 56 windows. And they say, we can't replace them all now because we have a production problem and, we can't supply 56 windows right now, but we'll replace 33. They replaced the 33 windows in 1999. And then in 2000, a year later, the windows that were not replaced, there were 56 that were bad, 33 were replaced, and by a year later, the ones that were not replaced are just like really about to completely fall apart. So Marvin sends another inspector out in I guess in 2001, and they find that 21 of the windows are in terrible shape, including, and you say how we know Marvin has got a serious problem. 4 of the windows that they just replaced in 1999 have already gone bad 2 years later. And so, of course, the Neuhoffs are thinking, okay, so now you're going to replace the rest of those windows, right? And Marvin says, no, we're not going to replace the rest of them for free, but we'll replace them for 1/3 off. We'll give you a 32% discount. So you can, buy all the windows to replace the bad ones at a discount. And the Neuhoffs they go, great, that's a great deal. We'll take 21 windows at 32% off. Is that what they do? No, y'all should be.
No.
No, they sue them. They say, Marvin, we hate you. You lied to us. We thought you were going to replace all the windows for free. And now you're saying, no, you'll replace them, but we got to pay 2/3 the cost of it. So they say, no, no, no. So they sue. All right. And what is the promise that they're suing on? We talked about it in this class, so it shouldn't be that hard to come up with. What's the promise they're suing on? Or where did the
They
promise?
Maybe
Okay, it's nobody to everybody at once. Okay,
maybe promise to repair the warranty.
no, they're not. So when they, so it's important to understand the promise that they're suing on is not the warranty. They're not like looking at a piece of paper that came with the windows and said, these windows are guaranteed not to decay for 7 years. We don't know what the warranty on they don't mention that in the case. So we don't know exactly what it said, but they're suing on the promise when the first inspector comes and says, we'll replace 33 now. And then, so it's that indefinite promise, like, since we're replacing 33 now because we have a production problem, so that's implying that they'll replace the rest of them later. What if Marvin had just come and said, we'll replace 33 now, and didn't say anything about their production problem. It's a different case, right? And that's the thing to understand about these common law cases. Like, everything revolves on what the facts are. You change the facts, you change the result. Marvin is in trouble because they said, if they just said, we can only replace 33, that's it. We'll replace 33 for free. And then they replace 33. What would the Neuhoffs be suing on? They'd really have nothing, right? The reason they have a lawsuit is because Marvin didn't just say, we'll replace 33. They said, we'll replace 30. We're only going to replace 33 because we have a production problem, which implies that when they get their production problem worked out, they're going to replace the rest of them. So that's how, the point is, that's how indefinite the promise is that the Neuhoffs are suing on. So, but then the court goes through all of these different legal theories in the lawsuit. And the first one we talked about is the theory is that Marvin breached their oral agreement. And what does the court say about that? The court says they did breach an oral contract, and why not? The oral contract is based on that promise, right? That we'll replace 33 now, and then this kind of indefinite implied promise that we'll replace 33 now and we'll replace the rest later. And what does the court say about that? The enforceability of that promise that, yeah, we'll replace the rest of them later, once we get our production problems worked out. There's no what for the promise.
Consideration.
There's no consideration for the promise. Like, they didn't have to promise that. Do you agree with that? There's no consideration for that promise.
They get nothing.
Well, that's you could argue that they got nothing. So yeah, so Marvin got no value for that promise. The Neuhoffs didn't give them anything for that promise. Did the Neuhoffs give something up?
The Neuhoffs claimed that the oral contract was binding and there was a consideration. They alleged three types of consideration: forbearance of the legal claims, the time and labor expended assisting Marvin in connection with Marvin's promise to replace the windows.
Yeah, so that's
and-
good. So the Neuhoffs, they've talked to their lawyer. They read their lawyer went to U.S. law school. He knows these cases about consideration. So they're trying to say there was some consideration. There was some consideration. So, and the thing that's important to understand at this stage is, remember those legal standards I talked about. For the court to throw the case out without ever having a trial, they have to construe everything in the Neuhoffs' favor. They have to take everything the Neuhoffs say is true and construe everything in their favor. And really, I'm not sure that they did that. You know, they talk about the time and labor and they say, well, there's not much evidence of time and labor spent. And that's not really the standard. You know, for the court to throw the case out there would really have to be no evidence that they expended any time and labor that could be considered consideration. But this is a practical matter, is what the U.S. courts do. They go like, it's not really the legal standard, but we just don't buy that. And so they throw it out. It happens all the time. It makes the law very confusing. Did the Neuhoffs give up anything of value? If they gave up, so that's the legal rule for consideration. Did Marvin get a benefit, or did the Neuhoffs give up anything of value to them for this promise? What do the Neuhoffs argue? What valuable thing did they give up? Because of Marvin's implied promise that they would replace the rest of the windows when they got their production problems worked out.
A reputation.
Well, that's a different thing. So the one of the things the Neuhoffs argue is, yeah, Marvin Lumber got consideration because this was a benefit to them. It benefits their reputation. What does the court say about that? The court says, that's kind of vague. We can't really quantify that. That's hypothetical. We can't really say that that Marvin their reputation benefited. And actually, under the strict legal standard, that's probably wrong, because what you would do if you were the plaintiff, the Neuhoffs, what you would want is a trial to prove that Marvin benefited, got a reputational benefit out of that. And so you would try to come forward with some kind of evidence that somebody wrote a nice article in the paper about the Marvin Lumber Company, about how they keep their promises, and or how they got some other business, some friends of the Neuhoffs decided to have buy Marvin Lumber Company windows because they were so impressed with the way that the Marvin Lumber Company backed up their product and backed up their. So you would, if you were the plaintiff, you're saying, let me go to court and prove that there was consideration because Marvin Lumber Company got a benefit. But this happens in the courts all the time. They cut it off. They say, we're not going to have a trial about that. We're just going to say right now, we think that's too far-fetched and too hypothetical, and we're not going to allow that claim. Technically, under the legal standard, it's not correct, but it happens, all the time. And it's a lesson for you in, bringing claims that are a little thin, a little tenuous. You don't go to court unless you have a really strong claim, because the courts will say, you might have a legal theory and you might have some evidence to support that, but we just think that that's, not really likely. We're just, going to say, no, you can't, we're not going to accept that claim. But the court does discuss a little bit more the other theory that the Neuhoffs argue, which is that they gave up something, that the promise that Marvin Lumber Company made to them to replace the rest of the windows later after they replaced the first 33, that the Neuhoffs gave up something for that. And what do the Neuhoffs say they gave up?
It was Nijhoff's three types of consideration. The first is forbearance of their legal claims. The
Yes,
time.
that's it. The forbearance of their legal claims. Like, we could have had a legal claim against you back there in 1998 or whatever it was, and we didn't sue you because we thought you promised to replace all the rest of the windows. Does the court say that forbearance of a legal claim is consideration? Would that be consideration for a contract?
No.
Well, actually, so here's the thing that's important to understand. The difference between the legal rule and the facts of the case. So you're right. The court says no, the court doesn't accept that claim, but the court does accept that rule. And remember, there's a place in your case brief for, what is the rule of the case? And the rule, the court accepts that. That's the legal rule, that forbearance of a legal claim could be consideration. If I, if I had a right to sue to sue somebody because they ran into my car and they should pay the damages for my car. And if I say, you know what, I could sue you for that. I'm not going to sue you if you'll paint my house. Is that a legal contract? Is that a valid contract? I'm not going to sue you to make you fix my car, just paint my house. Is that good according to that rule?
No.
Why not? Think about that contract. You wrecked my car. You should owe me money for the car. I could sue you and make you pay, but I say, no, I'm not going to sue you. Don't worry about my car. Just paint my house. Is that a valid contract? Is there consideration for that contract?
Yes, because
Yes,
there was
because I'm
forbearance.
forbearing my legal claim. And the court says, so the rule is, and so that's where you reading this carefully, distinguish between the legal rule and the holding. So the legal rule is that giving up a legal claim is consideration. You're giving up something for what you've got. That's consideration. But the court does say in this case that that they did not give up their legal claim, and it's for kind of a, I would say, not construing everything in the favor of the Neuhoffs. The court says, well, you never threatened to sue them, and therefore you never gave up the claim. That's a little bit, kind of a tight logic. So the court says the rule is, if you have a legal claim and you give it up, that is consideration. But they say, well, the Neuhoffs didn't really give up a legal claim because they never threatened to sue. And so they never said, there was never this exact express transaction where the Neuhoff said, we could sue you, but we're not going to sue you because you promised to replace the rest of the windows. So theoretically, it could happen. The court says theoretically that could be consideration, but that's not what happened in this case. So it's a little confusing because the legal rule is that giving up your legal claim is consideration. You could argue, if I were the lawyer, I could argue that the Neuhoffs did give up a legal claim, but the court says no, because it was not definite enough. And a lot of these things in here, the court is saying this is not definite enough, and there was no definite legal claim, and they didn't, explicitly say we have a legal claim and we're giving it up. So, you know, the lesson to you as a lawyer is that, you know, the Neuhoff should have written Marvin Lumber Company a letter saying, we're not suing you because you promised to replace the rest of the windows as soon as you solved your production problem. You know, if that had been the case, then it'd be a different result in this case. There would be, you know, an explicit expression that they gave up a legal claim. But the court says that's too vague. They never talked about a legal claim, so we're not going to enforce that. Again, you know, legally suspect, but that's what the court did. So that was all the treatment of consideration. And then they went on to talk about a different theory under letter B, which is promissory estoppel. So the Neuhoffs, they lose all their contract claims. And let's see, where did they? Let's come back to the promissory estoppel, and let's talk about the other theories first, the theories they reject. So under the capital letter C, under implied warranty, the court says, we're not going to enforce a warranty, and why not? Capital letter C, implied warranty. So warranties, I'll give you all the answer. Nice professor could give you the answer this time. Y'all are going to have to start reading this and digging this out for yourself. So the court won't enforce an implied warranty because a warranty is for the sale of goods. So the windows are considered goods. Goods, that's just a product. The windows are a product. If Marvin Lumber Company sold windows to the Neuhoffs, you could have a warranty on the sale of goods. But the court says this was not a sale. This was a promise that they would replace some windows that had, you know, they had already sold. And so they said that promise was not a sale. A sale is I give you money and you give me something, and this is free. The Marvin is replacing the windows that they've already supplied the windows in a sale. There was an original sale. The Neuhoffs bought Marvin windows, but this is beyond the sale. This is after the sale. They're promising to replace the windows, and the court says that's not a sale, and warranties only apply to the sale of goods, and this is not a sale of goods. So when you're you know, analyzing things as a lawyer, you have to look at all of these elements and make sure that all the elements are satisfied. So for a warranty, you have to have a sale of goods, and they said there's no sale of goods here because the promise was not a sale. And then they look at the Massachusetts law, which is the statutory warranty, and that is the law that says what you have to do to make a manufacturer replace a defective product. And they say there are two reasons that the Neuhoffs can't enforce that statutory warranty, because one, the statute, under a statute, you have to meet very specific requirements. This statute says that they had to send a written demand to Marvin saying, you know, these windows are defective and you have to replace them, and you have to do that within a certain time. And they never sent that kind of a demand. and they didn't do it within 4 years, which is the statute. You understand what a statute of limitations is under the law. Even if you have a case, you have a certain amount of time to file it, and that's called the statute of limitations. And if you don't file your case within that time, doesn't matter how good your legal theory or facts or evidence or anything is, if you don't file it within that time, your claim disappears. So the Massachusetts law, they had 4 years to file. And obviously we know in this case that, it was 7 years after the windows were installed that the Neuhoffs first communicated with the Marvin Lumber Company, so that the statute of limitations had expired, so they had no claim. So those are all the things that they lost on. And you could argue that the court did not really construe everything in the Neuhoffs' favor to decide that. But then going back to capital letter B, promissory estoppel, they decide that in the Neuhoffs' favor. And again, it's very important. The court lays out the legal rules, what you have to have promissory estoppel. And what that means is that there's a promise that doesn't really amount to a contract, but the court is going to enforce it anyway. And the things that you have to have is, first of all, you have to have a promise. Did we have a promise in this case?
Yes.
Yeah, well, that's what the court says. Actually, the trial court, the original court, we're reading the appellate court opinion that's reviewing what the trial court, the lower court, did. The lower court actually said there was no promise. And what was the reason for saying there was no promise? What would you argue? Even if you didn't read this, what the court said here. And I've talked about it already in this class. How would you argue there was no promise? There was no promise to replace the rest of the windows. Well, what the trial court said was that it was too ambiguous. They promised to replace 33. The promise to replace the rest was a little vague. It wasn't very specific. They didn't say when they would do it. They just said, we're only replacing 33 now because of our production problem. They didn't explicitly say, and we'll replace the rest later. So that's what the trial court said. But the appellate court said, yeah, that was a promise. And you have to stretch a little bit to imply the promise, because they said we're replacing 33 now because we can't produce all 56 right now. So that's implying that when they can produce them, that they will supply them. So you have to have a promise. And then, but you can't just have any old promise. And go back to Daugherty versus Salt. I can promise to give you $3,000. Tatiana, right now, I'll promise to give you $3,000. Can you go to court and make me pay?
No, because there was no consideration.
That's exactly right. It's a good.
We are recording that.
Okay.
I can prove this in a court from video record.
You can prove my promise, but you can't enforce it in court. That's great. So but what if I say, Tatiana, I will promise to give you $1,000 if you stand out in the rain with no hat or raincoat on for an hour. And then you go stand out in the rain for an hour.
There was a promise because
because you took an action based on my promise.
Yes.
So I can make a gratuitous promise, give you $1,000. You can't take me to court. But if I make you a promise that, and what the way the rule is written in the case, that creates a reasonable expectation for you to induce action or forbearance. If I make a promise that gets you, that you could you could reasonably expect that you would do what I asked you to do, or you would not do something that I asked you to do, then that could be enforceable. What if, so the rule that element, so we're talking about the elements of a claim, and this is really important and really basic. But when you're working as a lawyer in these cases in the common law courts, you got to break down what are the elements of a claim. So for a promissory estoppel claim, what first element is a promise. So I promise to give you $1,000. That's a promise, right? So that's one element satisfied. And then that you would reasonably be expected to act on the promise. So if I say, Tatiana, I promise to give you $1,000 if you go stand out in the rain for an hour. And then you go to court and say, he made me a promise which he could have reasonably expected that I would go stand out in the rain for an hour. So therefore, court, order him to pay me $1,000. Does that work?
It still doesn't work because
No.
we haven't. No?
Because she didn't do it. So it has to have a reasonable expectation that she would do it, and then she has to do it. So if I say, I'll give you $1,000 if you go stand out in the rain, there's a promise. I could reasonably expect she might go out and stand in the rain for $1,000, and that's a detriment to her, right? That's like she's, she don't want to go stand out in the rain. But the promise and the reasonable expectation are not enough by themselves. Then she has to actually go do it. So these are the elements of the claim. And then the final element is that enforcing the promise is the only way to avoid some injustice. And what's the injustice? She's like, I stood out in the rain and I got wet and I made a fool out of myself and I caught a cold, and all based on that lying professor's promise. So and here the court kind of struggles to find all of those elements. So for the first part, remember the trial court said there was no promise. And the court here admits that the problem is really vague. The promise is really vague. Marvin Lumber didn't really promise exactly when they would replace the rest of the windows. But then the court goes into some legal reasoning and they find some cases that say you don't have to have all of the terms of your contract to be, completely exact, and you can have some missing terms and ambiguous terms. It can still be an enforceable contract. And so therefore the same thing can apply to the promissory estoppel claim. And so basically they say it wasn't very clear, but it was clear enough that they intended to say that they would replace 33 in the first batch, and that implied that they would replace the rest. And but then remember, for promissory estoppel, the next part of the claim is the person who receives the promise has to rely on the promise. So you have to have easier thing to remember than these things that they lay out is there has to be a promise and you have to rely on the promise. So what did the Neuhoffs do to rely on this promise? The promise is a little vague, but the court says it's vague, but we're going to say it's a promise. They promised that they would replace 33 now and the rest later. That's the promise. And then the next part of promissory estoppel is, what did the Neuhoffs do to rely on that promise? What did they do or not do that they wouldn't have done if it were not for the promise? What does the court say? And y'all might, and y'all's benefit of the doubt, y'all might be struggling with this because some of it doesn't really make a lot of sense. It doesn't make a lot of sense to me, but these cases, they spell out what the rules are. How they apply the facts to these rules is a little murky. But what is it? Anybody figure out, what did the court say that the Neuhoffs did relying on the promise to replace the rest of the windows?
They didn't get a claim.
They didn't get the what?
Claim.
They didn't get the claim. Well, what the court says, well, another thing that was complicated about this case is there were some letters that went back and forth between them, and none of them talked about this promise. And the court dealt with that by saying, well, the letters that they wrote back and forth didn't contain the promise, but the letters also didn't say that Marvin Lumber would not keep that promise. So again, that's the court straining and stretching a little bit to help the Neuhoffs. But what the court said, the appellate court said that the Neuhoffs did in reliance on the promise, and remember the promise is, we'll replace 33 now and we'll replace the rest later. That's the promise. They kept the first part of the promise. They didn't keep the second part of the promise. So what did the Neuhoffs do in reliance on the second part of the promise? And the court says, when they went to get a bid to replace the windows, they didn't get a bid on replacing all of the windows. They only got a bid on replacing the first 33 because they thought Marvin Lumber promised that they would replace the rest later. So they only got a bid on the first 33. That's what the court claims that the Neuhoffs did in reliance on the promise. Maybe not terribly convincing. And again, the point of this is, that's what the court decided. As a lawyer, you should learn to read all these things. And actually, this is the final opinion, where it's really most important is when you're arguing in court and before the court decides, and you hear the court saying something like this, and be prepared to contest it. So for example, think about some of our other cases, what you would argue. So when the Neuhoffs were arguing that there was consideration because it would have helped Marvin's reputation if they replaced all the defective windows, all the decayed windows. And the court says, no, that's a little too vague and hypothetical. And what would you jump out and say? The court says that's not enough consideration. There's not enough consideration there. Their reputation, we can't quantify that. We don't know how much their reputation would have benefited. So we can't say that's enough of a benefit to call it consideration. And you would jump in and say, what about, remember that case we read about the peppercorn the peppercorn theory of consideration, that even a peppercorn can be consideration. Remember the case where they said it was all about arguing about the guarantee, and they said, well, we're not sure if the guarantee was any good, but he gave him a piece of paper, and the piece of paper was consideration. You know, here the Newhoffs wrote Marvin Lumber Company a letter under the theory of that crazy case. They could have said the letter was consideration. So, you know, for what the court said was not good consideration in this case, there's another case that says that there was consideration, that the court can't really say it's not enough consideration. We have other cases saying that like this tiniest little thing can be consideration for a promise to make it an enforceable agreement. And I hope y'all have learned something from struggling through this case. It was a little, like I said, the assignment maybe wasn't very clear, so we didn't get all of the case briefs. Anyway, now that we have painfully struggled through this one case to see how this works, I want all of y'all to do a case. Well, actually, not all. I'm going to divide the class at half. So we had 3 cases for today. We've only, kind of painfully, laboriously discussed one of them. We're going to go through the next 2 next time, and I'm going to divide the class in half. I'm going to get half of y'all to write a case brief on what's the other case? Matei versus Hopper is one of the cases, and the other case is McGraw-Hill versus Weiner or something like that. And I'm gonna get half of you to do, let's say, like, if your last name begins in A through L, to do Matei versus Hopper, and if your last name is M through Z, to do the other case, and write a case brief, which I want y'all to turn in time for me to try to read them before the class, which means y'all need to turn them in by Monday at 5 o'clock Kyiv time. So y'all should be able to get the feel of this, because we've struggled through this for 2 classes now, to be able to kind of get the feel of it and try to do this for yourself without the professor doing every step of the way. And so that is your homework for the next class, to try again to do the case brief and turn it in time for me to read them, and then we can discuss your briefs and talk about them, and where they're good and where they can be improved. And then after we struggle through this one more time, we'll I think move on to next subject will be the rules of interpreting contracts. But I think we have to really kind of struggle through and understand all these terms. So I'm going to send you that chart again, which is, identify the issue, identify the position of the parties, the key facts, the rule of law the court relies on, and then the holding, which is how the court applies that rule to the facts of the case. And we will do that for next time. And y'all, since y'all are kind of quasi almost University of Alabama students, you got to remember to pull for Alabama, which is playing for the national is the #1 rated basketball team in the country and is playing for the national championship this weekend. So y'all pull for your team, the Alabama Crimson Tide. And I will see y'all next Wednesday, and we will struggle through this one more time, and hopefully y'all will have it so down pat that we won't have to do it again. And thank y'all. See you next time.
Thank you.
Thank
See
you.
you next time.
Thank you. Bye.
Thank you. See you
Have
next
a
time.
nice day.
Thank you for the lecture.
Thank you. Goodbye.
Thank you. See you.
Thank you.
Thank you.